E tūana I raro I ngā taumata kōrero ko te wehi ki te atua te tīmatanga o te whakaronoi. E tautonu ana ngā manakitanga o te runga rawa, ki runga kia kingi tū heitia pō te tau te whero te tua whitu. O ti rā kia tātou katoa kua rūme mene maira I roto I te karanga o tēnei pō. Tēnei te mihi kia kūtou me ngā tū āhuatanga kei runga kei a kūtou. Ngā mate tāruru nui kei roto I a kūtou. Tūhono tia mai ki ngā mate tāruru nui o te kāinga ne, ke kotahi te poroporo aki mō tātou I roto I tēnei rā. Ka tangihia ngā mate rātou kia rātou. Ka whakanuia te ora tātou kia tātou. Tēnei te mihi, tēnei te mihi, tēnei te reo whakatau I a kūtou I a tātou katoa. Me pēwhea hoki I te mihi atu kia kūtou, Sir Anan, tēnei te mihi kia koa. O tira kia koe Neil, ka nui te mihi kia koe. O tira me ngā mana whakahaere o tō tātou kaupapa o tēnei rā. We are really fortunate to have the Honourable Margaret Wilson amongst us to share the nitty-gritty stories of the beginning of Te Piringa Faculty of Law. And just to start, I wanted to reiterate a kōrero from Te Riki Nui Dame Te Atairangi Kāhu at the opening of the facility that was led by Kaumatua John Haunui and Tui Adams when they did the karakia. And she said, waiho ko te whakapono rāua ko te ture pai here tia kia kotai. Let the spirituality and let the law become one and let them be bound together. In the immortal words of Pōta Tau Te Whero, ko te ture, kia mau ki te ture, kia mau ki te whakapono, kia mau ki te aroha, hei aha te aha, hei aha te aha. And it's absolutely fantastic to be here, and although we couldn't celebrate the 30th year on the 30th year, because, you know, the blimey COVID keep getting in the road, but it's absolutely fantastic that after 30 years, we are able to come back together and to share stories from the beginning, through the middle, and now with the leadership of not only Te Piringa Faculty of Law, but with the division in its entirety and with the University of Waikato. And we celebrate now. And it's absolutely fantastic to see the community leadership. Paula, tēnei te mihi aki kia koe, parekawhia, tēnei te mihi kia koe, working together. It's absolutely fantastic to have the leadership of Te Whakahiapo amongst us this evening as well. He no e te whānau, he whakatau tēnei kia kūtou, kia tātou. He whakatau tēnei kia kūtou, kia tātou, I runga I te ngā kaumahaki, I runga I te karanga, hui hui a mai rā tātou kia kotahi. Let us come together in celebration of the 30 years of Te Piringa Faculty of Law, tēnei te mihi, tēnei te mihi, tēnā kūtou, tēnā kūtou, tēnā tātou katoa. Right, that's my job done, whānau. So I'm going to pass now to the first of our speakers, and to Takurangatira, Patrick, is going to come up and give us some kōrero before inviting the next sort of set of keynote speakers for us this evening. Nō reira, tēnei te mihi ake kia kūtou, tēnā kūtou, tēnā kūtou. Kia ora mai tātou katoa, e Takurangatira, Pātariki, kai a koe te wā.
Kia ora katoa. Thank you for what a wonderful, warm welcome. I hope I can match that in some way. I'm Patrick Lehman. I'm the Pro Vice Chancellor for the Division of Arts, Law, Psychology and Social Sciences. Great privilege to come and speak to you today. Very briefly, to give an introduction to this marvellous celebration of 30 years of a distinctive and internationally ranked Faculty of Law. It's also obviously a huge honour and a pleasure to welcome Professor Margaret Wilson, known obviously as a distinguished lawyer, academic, politician, and perhaps approaching the status of New Zealand national treasure. I'm not quite sure on the rules here, but I reckon she is. But of course, many of us know her as well as a colleague and a great friend of this university, as well as someone whose name will always be connected with Te Piringa. We're celebrating 30 years, a little late, but you know, we can all lie about our age occasionally, of what I think is a unique faculty. A faculty that has always had a reputation and a tradition of distinctiveness, groundbreaking research and excellence in education. An emphasis on a progressive approach to law, founded on the three principles of biculturalism, legal professionalism, and the study of law in context. And those 30, maybe 31 years, have given us what will be, when they graduate, 30 cohorts of young people and old people as well, who will be the future generation of lawyers, both here in Hamilton and across the country and around the world. That is an impressive legacy for any institution, and given the priority that the faculty has placed on such important education, such important characteristics, a huge benefit to all of society. Now, those founding themes run through all that the faculty does, both in its internationally ranked research, did I get that in there again? And in its education. But of course, the faculty has grown. Te Piringa is now a significant size, with an international faculty of researchers and of students, and focused not just on those founding principles, but on the future. And the future challenges that all of the world and New Zealand will face: environmental and future law, international law, the internet, Maori and Indigenous governance, and crises in energy and food. In fact, the reaches of law at Waikato and of the faculty now extend beyond the beautiful building at the top of the hill. The future is in engaging in those interdisciplinary connections, in informing the research of others, and at the same time being informed by the research of others. It's a future that is incredibly positive, and I know that the faculty, the division and the university is going to embrace. I feel I'm repeating what's been said before, but I do want to acknowledge the Mayor, members of the law fraternity, and perhaps sorority as well, alumni and distinguished alumni, and finally, all of you for joining us today. It's now a great pleasure to welcome Professor Alpana Roy, the Dean of Te Piringa, to continue before we welcome Margaret to the stage. Alpana.
Ena mana, ena reo, tine timihi a Te Piringa kia koto. Tina koto, tina koto, tina koto, katoa. Kia ora, thank you very much for that very warm mihi, Rahui Papa and Professor Patrick Lehman for the welcome tonight. For those of you who don't know me, my name is Professor Alpana Roy, Dean of Te Piringa Faculty of Law, and I'd like to extend a very, very, very warm welcome to everyone here in the room tonight and those watching online. Thank you all very much for attending our belated, thanks to COVID, 30th anniversary celebratory lecture by our founding Dean, Emeritus Professor Margaret Wilson, as she reflects on Te Piringa's 30-year journey. Te Piringa Faculty of Law is very proud to be celebrating our 30th anniversary. As Rahui Papa mentioned, we actually turned 31 this year, well into our middle age. Te Piringa was founded in 1991 and is now one of Aotearoa, New Zealand's leading law schools. The faculty, as Professor Patrick Lehman mentioned, the faculty was established upon three core principles: professionalism, biculturalism, and the study of law in context. And these founding principles continue to be deeply embedded in our teaching, in our research, and in essence what we're about as a faculty. Since our very beginnings, we've always looked to push the boundaries of biculturalism, professionalism, and legal contextualism. And to draw upon a fairly recent example, in March this year, the New Zealand Council of Legal Education, our regulating body, passed a resolution that Te Ao Māori concepts, particularly tikanga Māori, would need to be taught in core LLB subjects. And while this was seen to be a fairly bold move in some parts of the country, this is something we've been doing in Te Piringa for 30 or so odd years. Similarly, you would have seen flyers in the room tonight about Te Piringa's app for the New Zealand Law Style Guide. This is the first such legal referencing app in the country, and again demonstrates our innovation and our drive to set new standards and to think differently. Now, to turn to our speaker for this evening, our founding dean, Emeritus Professor Margaret Wilson. It's a tremendous honour for me to introduce Margaret, although she really doesn't need an introduction. As is well known around the Motu, Margaret has had an extensive career in public service, including roles as founding member and vice president of the Auckland Women Lawyers Association and member of the advisory committee to establish a Ministry of Women's Affairs. From 1985 to 1989, she was a director of the Reserve Bank of New Zealand, and from 1988 to 1989, she served as New Zealand's Law Commissioner. Margaret taught at Auckland Law School until 1990, and then she joined us to serve as our founding dean until 1994. She's had a number of high-profile roles, including President of the Labour Party and Chief Advisor and Head of the Prime Minister's Office. From 1999 until 2005, Margaret was a Minister of the Crown with a number of ministerial appointments, including Attorney General, Minister of Labour, Minister responsible for Treaty of Waitangi negotiations, Minister of Commerce, Minister for Courts, and Associate Minister of Justice. In 1999, she was elected a list member of Parliament, and from 2005 until 2008, she was Speaker of Parliament. In 2009, Margaret was appointed as a Distinguished Companion of the New Zealand Order of Merit. A trailblazer, an absolute giant, she was not only the first woman dean of a New Zealand law school, but also the first woman president of the Labour Party in this country, the first woman Attorney General, and the first woman Speaker of the House of Representatives. Margaret, I'm standing here tonight, along with all of Te Piringa's former law deans, because of you. Thank you for your vision, for your inspiration, and for your sheer determination for establishing a truly unique law school here in Aotearoa. Dear guests, if you could please all join me in welcoming our National Treasure, Emeritus Professor Margaret Wilson, our founding dean, to the stage.
Oh dear, after that introduction, what do you say except welcome, tēnā koutou, tēnā koutou, tēnā koutou katoa. It's very generous of you all and to ask me to talk this evening. But I do want to sincerely welcome and thank all of you who've come out this evening. I know COVID is still with us, but we will in fact get through it, and this event shows how we are starting to do that. But I also thank you for the invitation to participate in the 30th anniversary of Te Piringa. I think we can all agree it has been a difficult 2 years with COVID, testing the resilience of the best of us. And I was thinking that to some extent when I was talking with people before this lovely event, and thinking with our eminent Chancellor and how he and I were at law school together. So many years ago, I did reveal to him that I will be 75 on Friday. He assured me that was not actually too old, and that his wonderful wife will be reaching that age as well. But talking with Arnaud, if I may call you that, Arnaud, as a friend and as a supporter for too many years, it brought back to me how important the law is, and the law as a profession is, and how over many years we support each other. And I suppose that to some extent is some of the things I want to say this evening about the importance of a law school that nurtures that sort of culture. So 30 years is a significant achievement, and it's worthy of recognition, given the traumatic events that surrounded the establishment of the law school. And I shared this evening a little of those events with the wonderful Pacifica students who came to honour me with this wonderful tribute and the wonderful tapa that I have put on the stage here. And I shared with them that at that time, Te Piringa, or Waikato Law School as it was known then, in fact had a higher number of Pacifica students than Auckland. In fact, as an institution, we welcomed the Pacific, and they contributed so much to those early years and the culture that I think has distinguished Te Piringa over those 30 years and today. So I thank you, Juliana, and the wonderful future lawyers from the Pacific who will make a fundamental difference, I know, within their own culture, but within ours as well. So Te Piringa was established in troubled towns, and I'm sorry to disappoint you, but I did go through the last of my boxes, numerous as they were, on Waikato Law School as it was at the time, and realised much of it could never be uttered in public. that like the establishment of any institution, there are some things on tour, stay on tour. And certainly, as I threw out emails from disgruntled colleagues, the institution that was the Waikato administration and others from the community, I realised that 30 years on, we just didn't need to know. Someone, however, I hope at some stage when they write another history, either of the institution or of Te Piringa, that in fact they will be able to incorporate, at least in a footnote, probably sanitised, some of the observations, not only of my performance, but generally of how we were ruining New Zealand society. So I thought about that and thought, no, I don't need to go over that. I have already recorded much of what happened then in other forms, happy to do so again, but in this speech tonight, I didn't want to go over it. So I did what I feel most relaxed in, which was a little distance, a little analysis. And certainly, to be fair, Te Piringa was established in troubled times that marked the fundamental shift in tertiary education institutions, not only for us, but others as well. And also, I think, in the purpose of tertiary education. The policymakers at the time had a neoliberal model, and it was not surprising that what happened to the university was part of that model, which was seen as education, as particularly tertiary education, as being primarily for the benefit of the individual, who now paid student fees, and the notion of the community and society in general, I think, was probably secondary. The fact that universities, bless them, had in the past fulfilled both objectives seemed to have been lost on those policymakers who were driven perhaps by the assumption that we could be more efficient if we followed the market approach. It's significant then that Te Piringa was established with a specific principled focus that has grounded and sustained it during some difficult times. And I think in particular, the birth, if you like, is never forgotten, and the circumstances of the birth and this focus, in fact, is what has been enduring. It was founded, as the Dean has said, on the 3 po, or pillars of teaching law in context, developing a bicultural approach to legal education, and preparing students for the professional practice of law. There were, I must say, very high expectations at the time that the law school would in fact produce a different type of legal education. And as the Dean says, it's taken them 30 years to catch up to us, but we in fact have to be patient. And it is true that some people seem to discover the treaty and the teaching of law in the context of the treaty as something new. 30 years ago, we pioneered that. The founding document of Te Hauriki expressed those expectations in this way, and I think it's worth repeating them. Te Hauriki conveys in a literal sense the horizon that meets, where earth meets the sky in a practical sense, a meeting place of people, their ideas and ideals, in a spiritual and metaphysical sense, aspiring towards justice and social equity. It alludes to a philosophy that reflects concerns that humans have for each other. It aspires to an environment of participation, of challenge, debate and justice in the world as it was, as it is, and as we want it to be. The concept of Te Hauriki finds concrete expression in our proposal to create a law school at the University of Waikato. Kaumautua Hagi, the first kaumatua of the school, also expressed this view at the opening. Firstly, to provide Māori students with an opportunity to graduate in law. Secondly, to ensure that curriculum reflects how the law can take account of the rights of Māori to their land and culture. Thirdly, to undertake research to ensure legal recognition of Māori law, L-O-R-E, and law, culture and rights. Remains true today. At the same opening event, the then Governor-General, the late Dame Catherine Tizard, described the role of lawyers in these terms. Members of the legal profession assist individuals to pursue their rights and honour their obligations under the law. The balanced, fair-minded and often conservative advice provided by lawyers is a necessary part of our constitutional framework. It's often the task of lawyers to tell people what they don't wish to hear. I can attest to that. This requires a tough-mindedness that is most often first developed within their legal education. Law schools do have a responsibility to educate their students with an understanding of the role they play within the community and their responsibilities to that community. The philosophy of Waikato Law School and the University of Waikato will prepare their students to meet the challenges facing our community. So 30 years ago then, the expectations were high that Waikato Law School would make a difference to legal education and the role of lawyers in our communities and societies. This paper is not going to review whether those expectations have been fulfilled. Take far too long in this context to do that. For me, however, the best review for any educational institution is the students it produces, some of whom are here tonight. And they, in fact, are testimony to the success of the program. A look at the alumni tells us that, and I think would indicate the value and contribution the law school has made to the legal community. It's important, however, not to forget that the influence of Te Piringa has had on legal education in New Zealand generally. We've just heard one example, even though it takes 30 years. But shortly after lectures started, I organised hosted a conference on legal education to which all other law faculties were invited. It was an opportunity to explain our curriculum. And I noted after the event that other law faculties incorporated some of our initiatives into their degree programs: legal philosophy, dispute resolution, to name but a few, and of course the importance of te tiriti. I'm not sure if such a conference on legal education has been held recently, and I fear the competitive environment amongst universities may make such events difficult. It was difficult at that time. We were seen as competitors. I note, however, that recently Te Piringa has continued its reputation for innovation with the development of the Law Style Guide app. This is a real and major achievement. It may not seem so. For those of us who actually research and study law, it's a major breakthrough. Let me tell you, within our world, this is very significant. I thought this evening, however, I'd say a few words about the challenges facing legal educators in a society that has become increasingly divided. More specifically, I want to discuss why the role of law is important to a society that supports democratic principles and values. I'll also argue that Te Piringa is well placed to prepare our students for the challenges that such individuals in the community face and will continue to face, and therefore will be able to fulfil the expectation of the early founders. I'm pleased to say that a recent seminar organised by Juliet and Alberta on the faculty that had a presentation with Timothy Lindsay on the role of independence in the rule of law and the legal profession was, in my view, in the Te Piringa tradition of preparing our students for the role in the community. Although the term rule of law is frequently used, it's not always clear what it means in practice. Fundamentally, the use of the rule of law is seen as a means, actually, to resolve conflict and avert violence through an accepted set of principles and values. Although the notion, as was founded in the peaceful revolution of conflict, can be traced back to the writings of Greek philosophers, for those of us who were educated in the English common law tradition, the concept is associated with Dicey, the English jurist, who argued no person is punishable or lawfully can be made to suffer, except through breach of law established in the ordinary manner, that is, through normal legislative processes, and that no person is above the law, and that every person is subject to the ordinary law of the land. I thought of this principle during the recent controversy where the former members of Parliament should be subject to a trespass order after they breached those orders during the protests outside Parliament, and was very pleased I was not the Speaker. I would have made one of those rules-based decisions that would have been extraordinarily unpopular. However, Dicey, I must say, also emphasised there is an importance and respect, not only for the law, but for judicial decision-making as part of that notion. Dicey, when developing his views on the rule of law within English society at the time, was faced with the established institutions of power being challenged by those outside the power structures. Working people were forming political parties, trade unions, and demanding a say in the laws that governed them. Women were also demanding the right to be part of decision-making political class. The increasing conflict in society, therefore, provided an environment to seek an acceptable regulatory framework to manage conflict. An appeal to the legal framework had appealed to a society that lacked a written constitution embedding such principles and values. But the concept of law, rule of law, relied on a set of process rules. It didn't make assumptions, but they were based on the process, the way in which you actually apply the law. But they were grounded on the notion of the equality of people. That is, all people being treated the same according to the law. The elements of the rule of law, then, are associated with democratic practice and institutions that enact the laws that apply to us equally. Unless proper democratic practice is applied when electing our representatives to govern in Parliament, or I would say local government, the laws made in Parliament or in your local chamber, then they will lack legitimacy unless those rules are followed. This is why our electoral rules are so important, especially in New Zealand that lacks a written constitution. It's why the rules of Parliament that define the process of making laws are important. These rules, known to few, are currently being reviewed by the Standing Orders Committee and are open for public submission. The fact these rules are made by elected representative makes the election of those representatives even more important. If you want a practical example of how the notion of the rule of law can be slowly undermined, you need only look at what is happening in the United States. Republican-controlled state assemblies are steadily changing who can vote, where people can vote, and how they can vote. This, of course, will have an impact on future elections. Challenging these new laws has become constrained, however, through the politicisation of their judiciary. A recent release of the draft Supreme Court decision on the right to abortion has raised the whole question whether a judge's political ideology is more important than their legal knowledge or judgment. The end result of the politicisation of lawmaking process will be the legitimacy of the laws made through institutions where representatives do not reflect the communities to be governed by the rule of law. What we may be watching is a development of the notion of rule by law, not rule of law. Rule by law is common in countries governed by authoritarian regimes. Basically, this means if laws are made by institutions that are not legitimately democratically elected, then the laws passed by that institution will not be legitimate. In this context, it's interesting to note that the recent challenge in New Zealand to the legitimacy of the laws enacted to regulate COVID-19 pandemic. Most of those challenges have used the traditional route of filing actions in the courts, and there were several. Arguments have been centred on the authority of the government to enact laws that in one form or another have affected the rights of citizens. These arguments have usually invoked the New Zealand Bill of Rights Act or relied on the rule relating to judicial review to ensure the government or government agency followed the correct process for enactment. The basic issue is a balancing of individual and community legal rights as interpreted by the courts. I don't intend here, you'll be relieved to know, to give an examination of those cases, as I'm sure there'll be much academic legal analysis. They were, however, a test of the legitimate authority of the government to make the rules of the whole society, and the system seems to have worked for some. However, there was, another challenge to the government's legitimacy to enact these laws. The protests outside Parliament highlighted the direct challenge to the government. Although the original focus of the protest appeared to be the removal of measures to prevent the spread of the virus, it morphed into a general protest against the government itself on the grounds it lacked legitimacy to make laws. What has emerged from these groups is the notion of the sovereign citizen, to take action to pursue their interests that are to be enforced by their sheriffs. This movement has adopted the use of the terms such as sovereign, common law and sheriffs that appear to appeal to some notion of historical English rights. It's interesting that the leaders of these rights resort to the notion of the law for legitimacy. What they fail to do, however, is explain who confers this legitimacy on the chosen few to make laws for others. In other words, their challenge is essentially to democratic process, as much as it is to the government representatives of the day. Should we be worried about such views? I would argue that New Zealand has always been a highly contested political and ideological environment. So any response, I would only say, should also take account that it's important that we also maintain a democratic commitment to free speech. And if we are tempted to change that, then we should be careful of what happens when you tend to suppress the views of others. Manage, regulate, but never suppress. However, as legal educators, we have a responsibility to teach our students the rules that will enable them to respond to such challenges. Knowledge and understanding of legal rules is essential to enable us to professionally represent our clients. This knowledge was one of the 3 foundation po of Te Piringa approach to legal education. Without that fundamental knowledge of the legal system, we can't professionally represent our clients or explain why obeying the law is important not only to the well-being of the client, but also to the community. A reading of the law, however, does not always provide a clear answer, some of us have noticed, to the infinite variety of human behaviours. This is why we have rules for interpreting the law and appointed individuals, the judges, who hear arguments and make decision on the meaning of the law in a specific set of circumstances. Maintenance of the integrity of this process is essential for the rule of law to govern the behaviour of all parties. All participants must believe the system is fair, even if their argument does not prevail. The notion that everyone is treated equally under the same rules contributes to the fairness of the system. It is not the only element, but it is important, as is the recognition that laws must be interpreted and applied in their context. Increasingly, it's recognised that while we must be treated equally when before the law, we do not always come to the law as equals. Social, economic and cultural factors contribute to how and why we seek the judgment of the law. Increasingly, New Zealand society has recognised one side does not fit all, and we must accommodate the diversity within our society, within our own legal system, while preserving the fundamental elements of the rule of law that unite us as a community. The development of human rights law is an obvious example of how we have tried to accommodate difference and inequality within our legal system. Another more recent development is the incorporation of te tiriti within the legal system. Te Piringa was founded on this principle 30 years ago, and through its graduates and research has contributed to this slow but inevitable development. The challenge at the moment to this development comes from those who fear we are developing competing systems of governance and of law that will be divisive. An answer to this concern is an understanding of the concepts underlying the rule of law as being inclusive, but not always at the moment definitive. As the values that underlie Māori culture are becoming better understood, it's time to explore the notion of the rule of law within the concept of a Māori value system. I'm no expert on Māori values or culture, but we must look for common values rather than differences when developing our legal system. The current debate on te tiriti in a post-colonial context provides an excellent opportunity to build a more inclusive notion of the rule of law. And I would argue that those who have benefited from a Te Piringa legal education are well suited to contribute to that development. Enough from me. I want to thank you for the opportunity to be part of the 30th anniversary and to affirm the founding principles as being still valid today. Te Piringa and the university should be proud of its staff and graduates who are providing leadership in our society that develops a legal system that is inclusive of all. Thank you. Want me to come down? Good. Oh, I've just been told there are questions. I forgot that I used to be a teacher. Thank you, Vice-Chancellor. One always needs advice from someone wiser. Right, questions. Anyone have any comments or questions? I hope it wasn't a bit heavy. I thought it might be. But you can't take the intellectual out of the girl, really. It keeps lurking. I'm sure not everyone agrees, but I thought it was important to try and put a context around what is happening in Te Piringa. And it was challenging at the beginning because it was so new, to be honest. It's not so new now, but the principles remain the same. There is just a different context. And I think that's what I was trying to say, that Waikato University enabled those values, and Te Hauriki, in fact, would never have happened without the leadership at the University of Waikato at the time. And having laid down a principle basis, and it's interesting, I don't think there's any other law school in New Zealand that has such a guiding principled basis for what they do. Normally, law schools emerge, often, as I was saying to someone before, from mathematics departments, God help us. Anyway, I'm sure that was important, but it's other disciplines we emerged and developed. But here, we did it all according to the law, and an inclusive law. Good, thank you. Yes, Marie. Marion.
First of all, I'd like to say that you're a wonderful inspiration for young, youngish female academics. And you're a really inspiring mentor as well. And looking back on the last 30 years of Te Piringa, where do you see Te Piringa in 30 years' time?
An easy question, thank you very much. I suspect it will still be challenging if it remains. In other words, for me, the new challenge is technology, to be honest. I think it's also the issues relating to our constitution as a people and finding a way through. We have in the past, and I'm sure we can, but we have to keep on evolving and developing who is involved in that decision making. And I think Te Piringa can make a really good contribution there. I think on technology also, for what it's worth, because I wouldn't like to predict where we're going. I merely hope that Mr. Musk doesn't quite succeed with Twitter, but then I think maybe he will destroy Twitter, so who knows. So you're going to have all those issues about free speech, as I mentioned, about exactly who has access, and the divisions in society will probably come as much from technology, in my view, as they will from anything else. So, and that will be a resource question to some extent, actually, as well. So very important that we, in fact, have people who understand that. So the lawyers that hopefully come from us will be raising these questions, will be defending people in court, saying, what about us? This is a new set of circumstances. This is a new way to look at how we're going to consider the facts, how we're going to interpret the law. Pushing the boundaries, I hope, is what we'll be doing, and I don't see why we shouldn't. You can only fail to find that you're actually successful 30 years later. You know, I mean, that's the point, really. You can't take it personally. Probably not, actually, but I think the way in which that division is expressed is widely spread, in a way. I think we fool ourselves if we don't understand our own history and the divisions that there have been within our society. And I guess I say this partly as an employment lawyer. Some of the struggles that working people have had in this country, most people wouldn't believe today. The first strikes in New Zealand were by Maori workers. You know, I mean, as you see the evolution and development, and we're not good in our own history. That would be my view. I see now in schools we are going to get a version of it, so one only hopes it's an inclusive version. But I support the thoughts behind that. But I think the way in which it's expressed is different, and that's about the technology. I think that worry me more, and therefore how you manage to put a contestable view out there. That's going to be who controls, in fact, social media becomes really important. And it's privately controlled, not publicly controlled. By control, I mean regulated. Yeah. I think it has to be challenging of the students to think outside the norm. Just because the precedents tell you one thing doesn't mean you can't think about that. You can be respectful of it and where it comes from, but does it really fit this case? And therefore, is there another way? Now, the law only develops and maintains legitimacy because it does evolve and develop, and we do that through two ways. We do it by producing judges who get good legal education, and for which we do at Te Piringa. We produce judges too. But we also do it through sending people, and I hate to say this, off to Parliament, to be able to legislate the laws that, in fact, will be interpreted. So in other words, we contribute to the public life as well as the private citizen's life of all the myriad of problems we have in our lives that we need a lawyer for. So I think that's to me is important. Just push the envelope, constantly knowing what your client really is, being able to relate to your client and work often behind what's really worrying the client, and then looking at the context within which that is. And most of the breakthroughs come, I think, from lawyers, in fact, pushing the boundaries. Now, you won't always be thanked. And Dame Catherine was right when she said that. You're not always thanked, but that's your job, is to say what people don't want to hear, as long as it's obviously well-based in the law.
One more? Yes, over there.
Partly an observation. I was a student at Victoria University Faculty of Law in the 90s, and then recently graduated here in 2020. Was it by design or necessity around having non-restricted entry through the law school? And how do you think that's impacted the culture? Because I personally found it a lot more collaborative because students weren't competing against each other.
It's a very interesting question that should be explored in a better context of more knowledge. But my gut feeling is, I first experienced this when I was at Auckland Law School, where we had unrestricted entry when I went through, which is why most of us became lawyers, actually. Some of those who we employed wondered how. And then they restricted entry from about the mid-70s. And suddenly the number of women exploded in law because they had better grades. And that's how you got the imbalance, as some people saw it, in legal education between male and females, at least at Auckland. Over time, I'm not sure that has evened out or not, but I found that quite interesting. Here, our experience was, and the Vice-Chancellor may recall, but there's always caps on money, so how many, in fact, you can have in terms of students. The decision was made to have a different open entry, I suppose, and how we differed, there was no Maori quota. This was only the law school that did not have a Maori or Pacific or any other sort of quota. That, I thought, was extraordinarily important. I had no problem at all that we would, in fact, attract students, if not the first year, but through at least the first cycle, sufficient to equate with the number within Māori within our region. It seemed to me that you've got to take time, you've got to build it, you've got to do it properly. So that distinguished us at the time. And I think also what was different is it wasn't only on grades. There were, in fact, places for people mainly young men who had left school at 15 to pursue other more exciting activities, but came back to realise they needed a qualification and maybe they'd try law. And after a bumpy first year or so, they did extraordinarily well. Did extraordinarily well. They needed support and help. Now, that was a very interview, and we were criticised for that. There were questions in Parliament about who got in and who didn't. But it seemed to me there were people who had missed out on a legal education through sometimes quite arbitrary criteria. Now, in those days, maybe the financial constraints were perhaps not as great and we had some flexibility. I don't know. But certainly open entry seems to me, if you can maintain it, is extremely important, but also looking at more than grades. I don't know what others feel, and I took comfort in this fact, where often practitioners told me at the time, those with A grades did not make the best lawyers. Those with C grades didn't really either. But maybe in the criminal bar, I was once told, I don't know what that's in. But those who came in the middle were just perfect. A bit like Goldilocks, I suppose. Good, I think we've got to move on. I'll stay here.
Yeah, okay, thanks. E rā rangatira mā ngā pūkeng me ngā te wera o Te Piringa, tēnā hui hui tātou katoa. My name's Neil Quigley, I'm the Vice-Chancellor of the University. It's my great pleasure to be here this evening, first to help celebrate the 30 years of Te Piringa Faculty of Law. It's a great part of this university, and for all of the reasons really that Margaret has so ably enunciated in her talk this evening, including the very helpful question on open entry. Because I've of course worked at universities where there were degrees that didn't have open entry. Of course, they tend to be used to bring a lot of students into a degree for which there is excess demand, and then channel many of those students into a degree that they didn't really want to take in the first place. And so it's a really important part of this university's tradition that we don't do that here. And I think it's a great thing for the culture of the university and of course enormously to the advantage of our students. Because through that system, the best students always do emerge, and you don't need the sort of filter at first year that many universities have to achieve that. So I'm delighted to be here to help you celebrate. I'm also delighted to have the opportunity to speak at the end of Margaret's lecture. Since I came here to Waikato, Margaret has been the most incredibly supportive colleague, source of advice and encouragement as I've worked my way through my share of interesting and challenging issues. And Margaret, your support for me is so much appreciated. Thank you. So I won't delay you any further. I have not taken Rahui's advice and put a restriction on the bar tab for the closing, so that's open. Margaret, apparently I've bought you some flowers.
Oh, good. Well, that's kind of you.
Yeah, I thought so too.
Yes, very good.
Yes, let me get those.
Okay.
There we go. Thank
Really
you
good.
very much.
Oh, they're beautiful. I love you. Yes, someone will help me carry them.
Yes, I will. Yes. And just to close, e te rangatira Rahui, Maupai te tahi, he karaki a whakamutanga, motuhui, nā mai. Yeah. Kia ora.
Thank you. I shall return them to you, and I shall come down the stairs and we shall get the closure. No, Kay's going to help me.
It's okay, you can grab my arm and come.
Yeah, Kay?
It's okay,
Yeah,
I'll help you. That's fine.
Sure.
Yeah, of course.
Just going to just hand
Yep,
this.
okay.
Off you go.
Yep.
Kia ora tātou katoa. Ladies and gentlemen, what an honour and a pleasure to listen to Margaret Wilson. Ho mai te paki ki tō tātou marei kura. "30 years worth of memories and didn't drop the ball once. Ka nui te mihi kia koe." Ladies and gentlemen, as Professor Quigley has said, he hasn't put restrictions on the bar tab, so it's free for all after this. Kia ora, Neil. Here no, ko tāku he karakia, we'll present our final karakia before we invite everyone back to have some refreshments and some kai. Here no, what an absolutely fantastic way to celebrate 30 years of Te Piringa Faculty of Law, and just to reiterate the words, tēnā koutou. Thank you all for your participation this evening, both in person and online, and may the next 30 years be just as strong without the speed bumps that Margaret talked about at the beginning. Nō reira, tēnei te mihi atu kia koutou, tēnā koutou, kia tau, kia tātou katoa. Te atawhai a tō tātou ariki aihu karaiti, me te arohao te atua, me te whiwhinga tahitanga ki te wairua tapu, ake, ake, ake. Āmene. Kia ora tātou katoa.